Good afternoon, everyone. Thank you for joining us this afternoon. This is the JCT 2024 New Contract Seminar. Just to give a bit of housekeeping, we are recording this seminar for our on-demand platform. Please feel free to ask questions in the Q&A box, or alternatively at the end, feel free to ask any questions you have as you may want to go on. To introduce myself, my name is Adam Davis. I'm Director and Head of the Construction Engineering Department here at Palmer's, and I will be giving this seminar today to run you through quite briefly in the changes to the JCT contracts. I will be saying next slide purely because we had a bit of a technical hitch, and our administrator is going to be dealing with the slides. So if I can have the next slide, please, Jay. So to give a bit of introduction and background, JCT announced back in June 2023 that it would be modernising its contracts. It was very brief in terms of what it was going to do, so it's been an anticipated release, sort of wait to see what was going to be in the new versions. JCT started to release its 2024 suites in April 24 this year, with the design and build version first. And currently, as at today's date, we now have the design and build suite of contracts, the minor works, intermediate building contract, and that would include intermediate with design, standard building contracts, and the consultancy and pre-construction services agreement, including all various subcontracts and other contracts you will need for those suites. JCT plans to roll out the remaining contracts throughout the rest of 2024 and early 25, with the aim that by the end of 2025, most people would have migrated across to the 2024 suites and stopped using the 2016. However, when and how people start switching over is entirely up to them, and we'll come on to that and touch on that slightly towards the end of the seminar today. If I can have the next slide, please, Joe. So what we're going to run through today is sort of a bit of background as into why now. We're then going to look at the key changes to the JCT, and throughout I'll be referring principally to the Design and Build 2024. Principally, the changes are the same for the main suite of contracts. However, there are some minor differences, obviously, with the minor works. Given the nature of the contract, some of the changes don't filter through into the minor works. But principally, most of the changes are the same, just the clause numbers change from contract to contract. So if I can have the next slide, please, Joe. So why now? Well, principally, the main reason is that the other forms of standard construction contracts have been modernised various times. So NEC4, for example, the 2017 version was amended in 2019, 2020, and then 2023. Excuse me. FIDIC 2017 was updated in 2019 and 2022. So JCT, having last updated the contracts in 2016, was well overdue a bit of an upgrade and overhaul in terms of how things have developed over the course of the last few years. And principally, there's been some changes in law, as everyone will know, such as the Building Safety Act, which came into force, court decisions between 2016 and 2024, such as the effective triple point and liquidating ascertained damages for delay at termination, which we will touch on. And as well, user feedback. Users wanted the contracts updated, principally because people were using a lot of schedule of amendments to update the contracts to reflect the legislative changes, which now with the 2024 version won't be so common. If I can have the next slide, please, Joe. So effectively, just to run through briefly the key changes, the first thing is the modernising and streamlining. And as we'll touch upon in a moment, it includes adoption of gender neutral language. So all the hises and hims have all been removed, and it gives increased flexibility around the use of electronic notices. And we will touch on the electronic notices in particular. There is a big change in respect of termination notices, which can now be, if elected, sent by email. New for the JCT 24 was the introduction of a new contract family to complement the suite. So there's now a JCT target cost contract, which wasn't principally around before, comprising main contract, subcontract, and a guide. That hasn't yet been released, but will be, I am told, by the end of this year. I can have the next slide, please, Joe. As I touched on earlier, there's been some major updates in respect of various different legislations, such as Part 2A of the building regs, termination, accounting provisions, payment provisions, reflecting how the Construction Act was meant to work, new insolvency grounds reflecting the Corporate and Insolvency and Governance Act 2020. And I will touch on briefly towards the end of the seminar some key changes which I was expecting to see but didn't see from other case law that has come in. So it may well be that there is less future proofing than first thought, and a lot of people, including myself, believe that the amendments to the JCT 2024 are a bit light touch in their approach. But the idea was to future proof it, so it includes these changes to reflect the objectives of the construction playbook, and it incorporates previously optional supplemental provisions such as collaborative working, sustainable development, environmental considerations into the actual main contract, so they're no longer supplemental, and you can't just select them, they form a part of the contract. Next slide, please, Joe. So to give you some idea, as we're going to run through a few changes now. So the first one is that the statutory undertaker in clause 1.1 has now been changed. The definition is now statutory provider. Effectively, the wording isn't that materially different from what a statutory undertaker was. It's just modernising the language in terms of what a statutory provider is. They are still the same. Then the second major change, as I said a minute ago, was the gender neutral language. So there's his has now become their, which, or the employer or the contractor. So there's no more gender identities within the contract, and that applies throughout every clause throughout the contract. And we're going to see a couple of examples on the next slide, please, Joe. So we can see there where I've highlighted it, the adjudicator gives their decision as opposed to his. And next slide, Joe. And there you've got the, instead of who, it's a which, and in clause 1.8.1, instead of his approval, it's the employer's approval and the employer's reasonable satisfaction. Next slide, please, Joe. As I touched on earlier, one of the big changes to the JCT is in relation to effectively coming to the modern world. And as you will all be aware, previously certain notices had to be served in writing by post, usually by recorded delivery. The new JCT 2024 has updated itself and reflects how people work in practice these days, including the ability to select at clause 1.7.4.2, the ability to serve termination notices by email. And email provisions are now included as to how all notices can be served. But with termination, you have effectively now two options. But it's in the contract particulars. Obviously, if you don't accept the clause in the contract particulars, if you don't amend the contract particulars to say that clause 1.7.4.2 applies, then it will be the standard version, which is that it's to be delivered by hand or sent by signed for first class post. But if you do select 1.7.4.2 as applying, then termination notices can be sent by email, but only to the specific email address noted in the contract. Or if that email address changes, you would have to notify them of that change. But I think that is an important change because it reflects how in practice and in business, we all administer contracts and deal with things going forward. The default position these days is email as opposed to post. If I can have the next slide, please, Joe. Another major change is the fluctuations provisions in Schedule 7 are now deleted, and that's moved entirely online. There was already in JCT and over the last few years various different fluctuation provisions online. They're now all totally online. They're no longer included within the written version of the contract. Another is in relation to funder rights, third-party rights under Schedule 5. now got 14 days notice for the funder to step in, and once the funder gives that notice, the contractor has 14 days to start taking on instructions from the funder if they choose to step in. Another important change was the Corporate Insolvency and Governance Act 2020. There are now 2 grounds added to clause 8.4.1, a moratorium and a compromise, which allows the employer to serve notice to terminate, and those changes just literally reflect the changes to the insolvency legislation. Go forward. Next slide, please, Joe. What I deem to be an important change is collaborative working. It's always been the approach of NEC to have collaborative working. JCT never really had that in its contracts, but now they've specifically included it at Article 3, which provides that the parties shall work with each other and with other project team members in a cooperative and collaborative manner, in good faith and in a spirit of trust and respect. To that end, each shall support collaborative behaviour and address behaviour which is not collaborative. It just codifies and really puts into the actual body of the contract the obligation to cooperate with one another to get these projects completed over the line. And the idea behind it is to stop some contractors who are being deliberately uncollaborative. Next slide, please, Joe. Another important change is the sustainability and environmental considerations. Now, we have 2 new clauses at 2.1.5 and 2.2.2 of the JCT contract. And these have been inserted in lieu of the old supplemental provisions in provision 8, both of which refer to the environmental impact of the works. They are light touch, but they highlight, in my view, the importance within the 2024 contracts that places on environmental considerations, which are becoming more and more important and prevalent, especially with the sustainability and the environmental considerations around the built environment and how buildings should be dealt with. It is worth noting that any instruction in relation to the environmental impact does not change the contractor's responsibility for design. The parties can expand on this theme by including enhanced requirements and consideration in the contract documents if they require. And often I would see that when advising and drafting JCT contracts, there will be a whole myriad of sustainability and environmental considerations in the employer's requirements, for example, and other contract documents that I would see. But what this does is it helps feed in those sustainability and environmental considerations. Next slide, please, John. We then have an amendment to clause 2.17, which relates to design reliability, and what JCT done adopted effectively what is now the commercially accepted definition of the standard of care, and that is that being of an architect or other appropriate designer carrying out similar works in similar circumstances. Before, the design liability was, in my view, a little bit, for want of a better expression, wishy-washy, but it now codifies to what is standard duty of care to do the design as if you were an architect or another appropriate designer carrying out similar works. Of course, that will only feature in those JCT contracts that have specific design elements to them where the contractor is taking on that design liability. So it won't be included, for example, in the standard minor works building contract or the intermediate building contract where there is no design. Next slide, please, Joe. We also have a specific exclusion of fitness for purpose liability in relation to the design to the extent permitted by the law. Reflecting the fact that typically this is an uninsurable liability and therefore is in the best interest of both parties to clarify that it does not apply. Whilst the 2024 design and build does not go as far as to include an overall cap on liability, the footnote at clause 2.1 of the JCT contract does highlight that it as being something that the party should probably consider doing. The guide also includes suggested wording which the parties may wish to adopt to deal with that specific liability in relation to fitness for purpose. Next slide, please, Joe. Moving on from design liability, we also have a number of changes in respect of time, which are very much welcomed, I think, from contractors. Delay claims were always a bit of a problem with how the contract was worded in respect of how contract administrators were to deal with delay claims. In clause 2.25.2 now, we've now reduced the time that the contract administrator has to notify the contractor of a decision in respect of an extension of time claim. It's now reduced down to 8 weeks rather than the standard 12 weeks. And additionally, the employer has to now request any additional information within 14 days of either the particulars of the delay being provided or the notification of the delay. These changes are important because previously there was no real time limit in terms of how long the employer had to request that additional information. But it was always understood that the contract administrator / the employer would have 12 weeks from the request of an extension of time to make its decision. By actually inserting a specific timeline within that additional information within 14 days, it gives certainty. Too often I see claims where the employer, for one reason or another, hasn't dealt with an extension of time claim, and then to try and delay dealing with it 6 weeks later, ask for additional information. That won't be possible under the 2024 unless the contract is amended. If we move on to the next slide, Joe. So I've just briefly here set out how the new regime works. So if it becomes reasonably apparent, it's a relevant event, and notice of material circumstances then has to be given by the contractor, which would be the cause of delay, the brief description, and identify the relevant event. Then this is all relatively the same as it was in 2016. You then provide the details and estimate in your notice, or as soon as practical thereafter. So the contractor then has to give the particulars of those delay events if it hasn't already done so in its notice of material circumstance. If upon receiving the notice on the particulars, the employer or the contract administrator needs more information from the contractor, then you have 14 days to request that additional info. And then once you've requested that, if you don't request that additional information, then your decision is due 8 weeks after the particulars have been given. If you do request the additional information, it will be 8 weeks after you requested that additional information. We can have the next slide, please, Joe. Clause 2.2, there's also a couple of new relevant events which have been added in. 2.26.3 adds in a specific reference to employer instructions relating to asbestos or contaminated materials as a relevant event. In terms of that is now a relevant event which the contractor can claim an extension of time if the employer instructs to remove asbestos or other contaminated materials which could delay the project. The second one is really as a reaction to COVID. We now have an epidemic relevant event. Many people remember, it seems like a lifetime ago now, that we had COVID and lockdowns. People were rushing around trying to work out what relevant event they could use to extend time because of the lockdowns and while everyone was dealing with changes to the law. And if we can have the next slide, please, Joe. And that leads on to clause 226.8, which again is an entirely new provision for compliance with laws after the base date. So this again is a consequence of COVID, with the myriad of lockdown legislation that came into force after the many base dates of contracts to allow for social distancing, number of persons on site, etc. And during COVID, a lot of people were using the force majeure, but obviously that wasn't ideal for both contractors or employers. But now, as we move on, you'll see that these are not just relevant events, they're also relevant matters. So the contractor now can claim an extension of time. So if you had a new COVID epidemic, the contractor could apply for not only an extension of time, but also for additional money if that delay has cost additional expense for complying with various different legislation such as PPE, social distancing, restriction of numbers of personnel on site, all manner of things. Next slide, please, Joe. As I mentioned, obviously one of the biggest changes in the industry has been the Building Safety Act 2022, which came into about predominantly following Grenfell and other issues. So some of the key changes centre around legislative changes arising from the Building Safety Act 2022. For example, we have the duty holders. There's a new Article 7 where they are now identified. So the new duty holder roles that are required under the BSA and Part 2A of the building regulations are now in Article 7. And clauses have been added to the main contract body to refer to exact provisions of the building regulations and the updates and the obligations arising from them in accordance with Part 2A, in which the same way as the old 2016 referred to specific obligations under the CTM regulations. Next slide, please, Joe. And of course, with the Defective Premises Act, which was again amended by the Building Safety Act, the JCT 24 Design and Build has been included to reference the Defective Premises Act 1972, which, as you'll all be aware, has been amended to reflect the changes from the Building Safety Act. And clause 2.17.2 now makes it clear that where the works relate to the design and construction of a dwelling, then the contractor's design liability at clause 2.17.1 extends to liability under the Defective Premises Act, and the consequence of that is the new 15-year extended limitation period for claims for negligent design of dwellings, where that property or that dwelling becomes uninhabitable. And uninhabitable doesn't mean that they can't actually live there. It has its own definition. So while being not able to live there is material, it's not the only consideration that the courts will take into account. Next slide, please, Joe. Another feature of the Building Safety Act, as you'll all be aware, is the higher risk buildings. But the 2024 suite does not deal with any of the additional amendments which are required to address additional legislative requirements. This is again reflecting, as I mentioned at the very beginning, a light touch effect to some of the changes to the design and build. This is one of the changes that I was expecting to see within the new JCT. So the design and build 2024 without amendment probably won't be suitable for higher risk buildings because it doesn't include the provisions required for the procurement of high risk buildings. It's yet to see whether the JCT are going to release any of the standard contracts that do, and that will hopefully feed through. But if not, then the only way to, when you're dealing with high risk buildings, is to have specific amendments, and that's why the JCT directs you to their guidance notes as to how you can include either a schedule, a supplementary checklist to deal with those specific requirements around the gateway regime and mandatory occurrence reporting, for example. Next slide, please, John. Moving on from Building Safety Act, we then have various changes to money and payment provisions and termination, and I deal with them all kind of together. As you'll all be aware, construction contract has to comply with the Housing Grants Construction Regeneration Act. These are statutory duties which you cannot contract out of, although you can contract into them. The JCT was close, but wasn't quite there, largely in respect of the termination payment. Is principally where the payment provisions for following termination didn't fully comply with the Act. So what has been changed? If we can move on to the next slide, please, Joe. So completion, this clause 8.7.4 has been amended to effectively deal with what happens at termination, and it effectively it inserts a new provision that deals with termination. Firstly, the Design and Build 2024 clarifies the position in respect of a subcontractor and what happens with the subcontractor at termination. In terms of where previously a subcontractor would be terminated immediately, the Design and Build 2024 includes wording to ensure that the termination of any subcontract is subject to any step-in rights, for example, that may exist through any collateral warranty or third-party rights. The subcontractor may, however, suspend its service following the contractor's termination while they wait for the service of a step-in notice. And if no step-in notice is served, the subcontractor can then terminate, and the subcontractor is entitled to relief during this suspension. Additionally, a new clause 2.29.5 has been included and has been inserted to clarify that where the contractor's employment has been terminated before practical completion, and we'll come on to this in a bit more detail, the liquidated damages effectively end at the termination date. So in essence, the biggest change, if we can move on to the next slide, Joe, and the next slide, sorry, because I've already dealt with that one, apologies. This is the termination provisions where they're updating him. So we now shall be 2 months after the date of completion. And it then calculates, it then adds in wording to deal with how the termination payment has been calculated. That was always kind of missing, weirdly, and codifies what is meant by the termination payment, which is the amount of expenses properly incurred by the employer, payments made to the contractor, and the total amount which would have been payable for the works in accordance with the contract. And then if we have to have the next slide, Joe. There's an entirely new clause 8.13 which sets out the payment process upon termination. And what it does, if we can move on to the next slide, hopefully people can see it. It's a relatively large change, but effectively, it effectively just sets out what the standard payment provisions are anyway. So it sets out things such as the due date for the termination payment, when payment notices are due, when pay less notices are due, what the final date for payment is. All those manner of things were effectively missing from the termination section, termination payment, and how it was calculated. That's all now been codified into this new clause 8.13, which is quite helpful, and I think will hopefully you never get to the point where you have to terminate the contract, but what it will hopefully do is prevent some disputes from occurring in the first place, where people were just unsure, shall we say, as to when termination payments were due, what notices need to be served, and when. If we can move on to the next slide, John. As I mentioned earlier, there are some new loss and expense claims in the JCT 2024. Apologies for the typo there, should say relevant matters, not relevant events. And antiquities should refer to contaminants. So I do apologise for the typographical errors. Loss and expense claims. So this just adds in the relevant events that we went through earlier into relevant matters. So you can now claim additional time and money for epidemics, changes to law after the base date, and dealing with any instructions to remove asbestos or contaminants. Next slide, please, John. As I mentioned earlier, and I mentioned a few times, one of the major changes was following the case of Triple Point, which decided a number of things. One of the things was the court settled the long debated argument as to whether the liquidated and ascertained damages could apply after termination, and the court held in Triple Point that they couldn't. So effectively, liquidated and ascertained damages now end at the point in which the contract is terminated, if it is, and the employment under the contract is terminated. And that's a new clause 2.29.5 in the JCT Design and Build. And what it does, as I said, is it just ceases that right to liquidate and ascertain damages for the employer. Next slide, please, Joe. Moving on from those elements, we've now got dispute resolution changes as well. There's a few changes to run through. We've already looked at one, which is the collaborative working. As I mentioned earlier, this was an optional provision. It's now mandatory in Article 3, and that there just sets out the wording for you. Next slide, please, Joe. Another change is the old supplemental provision 10, which was optional again, about the notification and negotiation of disputes. This has now been taken out of the optional provisions and inserted into a new clause 9.1. And what it does is it places obviously more of an emphasis on early resolution. It involves the senior executives coming together. The only difference between the JCT and the NEC now is that it's not a time-bound process as in the NEC. The NEC has specific timeframes within which things need to happen. The JCT doesn't. It's not suitable where contractor is required to undertake design of any kind or where bills of quantities are required. But the idea being is that if the parties can get together early, have meetings, discussions, resolution will be a lot cheaper and quicker for all parties concerned. Obviously, there isn't always going to be that resolution. And of course, the dispute resolution provisions have the same bite as they ever did in terms of arbitration and adjudication, obviously court proceedings. If we move to the next slide, please, Jay. This just shows where those changes are. So you've got the new clause 9.1 about the notification and negotiation of disputes there between the senior representatives of each party. And in the contract particulars, there is a feed in for 9.1 to comply, where the parties have to set out who their nominees are for those dispute resolution meetings to occur. Next slide, please, Joe. Again, with dispute resolution, we've got adjudication and arbitration has been updated. All that's effectively happened is that they've revised the list of nominating bodies to take out one of those nominating bodies, which doesn't exist anymore. And the other main change is just the wording of the adjudication and arbitration provisions within the contract particulars in terms of what happens when there isn't a nominated body, or if I'm making it clearer as to how you nominate a specific nominating body or adjudicator. Before, you had to make cross-out selections. Now you can. They've included a space for you to actually write in who the nominating body is. The idea that change came about from user feedback, where people were completing these contracts by hand, and sometimes original copies were lost and selections weren't entirely clear. And so there was a myriad of litigation to resolve who is the nominating body. Moving on to the next slide, Joe. We're nearly at the end, so we're going to just recap some of the key takeaways from today's rush through version of the JCT 24. Obviously, it's a more modern contract with the gender neutral language that reflects the times. There's more of an emphasis on collaborative working and early resolution of disputes. But remember, it's a template. It can be amended. You can amend the contract as to how you want. And indeed, if you wanted to use a design and build, for example, as I mentioned earlier, for a higher risk building, you're going to have to amend it in some way, whether that be via a schedule of amendments or by the incorporation of an additional schedule to deal with the higher risk legislation that we have from the Building Safety Act. The contract in terms of JCT is still quite contractor focused. It always has been relatively contractor focused. But I think with the additions of the relevant events and the relevant matters for epidemics and other matters, it's still very much contractor focused. A bit of advice in terms of only use the 2024 version when you're ready. There's nothing principally wrong with the 2016 version. Obviously, it just doesn't have all of the legislative changes. So, but I have, and I'm sure many people have, produced various schedules to incorporate those legislative changes. So only really use 2024 when you're fully ready and you fully understand it. There are some other changes that I was almost expecting to see, but didn't see, one of those key changes. And I think the reason why it didn't feed in was because the courts hadn't necessarily resolved the issue at that time. The main one being in relation to the contractor's right to terminate. And there's a case currently called Providence, where the TCC held that a contractor who has served a default notice and where the employer rectifies that default couldn't then go on and just serve a termination notice if that specified default was repeated. That case has now gone to the Court of Appeal, and the Court of Appeal have overturned that decision, whereby now confirming that the contractors do have the right, where they have notified a dispute under a default notice. And even if the employer rectifies that default, which would usually be payment within the time specified, and the employer repeats that specified default, the contractor would have the right just to serve a termination notice under that new case. It's yet to see whether that case is going to go all the way to the Supreme Court. We'll have to see. But that's probably principally why one of the changes weren't focusing on those termination provisions, although it would have helped because it would have been a bit more clarity. And the reason why that case is making its way through the courts is because the wording isn't 100% clear. And other than that, I think there's a few other changes where it was very light touch, as I mentioned before, about the environmental and sustainability. But that's pretty much it for the 2024 version of the JCT. I haven't seen any questions come in. Does anyone have any specific questions on anything? I know it's been a bit of a whirlwind stop to the changes. As I mentioned, they are relatively light touch. In principle, there's nothing major other than those ones I've identified today that's changed in terms of adding in new relevant events, matters, dealing with extensions of time. They're principally the main ones, and then obviously electronic notices and how they work. So if no one has any questions, I'll leave it open for a little bit longer just to see if anyone does. Then thank you very much for attending today's seminar. I hope you found it useful and informative. Next slide, please, Joe. Please do give us some contract. If you have any questions or follow-ups from today's seminar, feel free to either email me or telephone me, and I'll be happy to discuss any questions you may have.